What's up, guys? Brian Fell Law Group PLLC here with your Florida Law Weekly Case Update. It's the end of July. I think a lot of people are probably on vacation right now, but I'm here for you, giving you the case updates for this week. So this week there's a few cases. Just wanted to give you an update on. First one is Davis versus Davis. This one is a interpretation of a marital settlement agreement where the parties were pro se. They wrote their own agreement, and so they wrote this language saying that the husband would pay for secondary school expenses for the child, basically up to the age of 21. And so the wife, the former wife, interpreted this to mean, well, he was going to pay for the college expenses for the kids. The former husband said, no way, I'm not paying for college expenses. I said secondary school expenses. And so the trial court actually ruled in favor of the mom, saying that essentially it would be absurd for the court to interpret the contract as saying that it wouldn't apply to college when it goes up to the age of 21. The appellate court actually reversed and said this language is not ambiguous. Secondary school expenses is defined in the dictionary as basically between the period from elementary school to college. So it's that in between period. And that I guess theoretically you could go and be in secondary school, in a trade school or something like that before college. And it also had to do with interpretation of a contract as far as patent ambiguity. If it's something is patent or patently ambiguous, then the court really cannot look to extrinsic evidence and the party's interpretation of the contract, which is what the trial court did. The trial court said this language was actually ambiguous, and so it allowed for extrinsic evidence. But you can't do that if it's a patent ambiguity, unlike another ambiguity, which I'm blanking on right now, a latent ambiguity. If it's on the face of the contract, you actually cannot look to extrinsic evidence, and actually the provision itself has to be unenforceable if it's patently ambiguous. But the appellate court said, no, it's not really ambiguous at all. They use the term secondary school expenses, and that does not include college. So the former husband was not required to pay for the child's college expenses. Second case is Menendez versus Menendez. I'm sorry, Mendez versus Mendez. This is out of the fourth DCA. And this was one where the mom actually got a default judgment against the father got a default judgment against the mother for a parenting plan. And the court entered a parenting plan basically that the father presented without really making any findings under 61.13, which are required now. You have to actually have findings of all the different factors, specifically need to make findings. And even if you get a default against somebody, against a parent, you can't really get a default judgment on a parenting plan if the other party wants to be present and present evidence of the best interest of the child. So even though they're defaulted, they can still appear and present evidence on the best interest of the child for the parenting plan. And remember to always have those findings of fact of 6113 of the time sharing factors. You have to make those findings in the judgment. Next case is Hershberger versus Hershberger. This is out of the 5th DCA. This is another case of delegating authority for time sharing decisions to third parties. You cannot do it. Can't do it. In this case, they delegated authority to the father himself and the children, basically saying, well, the mom could have additional time sharing if the father and the children allow for it, if they want it, and also based on the recommendations of a therapist. You can't do that. It has to be the trial court is the one that makes the decisions. You cannot delegate authority to a third party. And even if it's partial delegation, let's say they have a set time sharing schedule, and then they say, well, you can get additional time sharing if the kids want it, or additional time sharing if the therapist recommends it. No, cannot do that. The only person that gets to make the decision is the court. Cannot delegate. Last case is Gragg-Rivera versus Gragg. This is out of the 5th DCA. I only noted this case because this is one where it had to do with findings of income for child support purposes. You have to have findings of income, of net income in your judgments and in your orders when they're establishing child support. You can't just attach the child support guidelines. Sometimes that's what people do. They'll just say, okay, child support will be this, and then they attach the child support guidelines, which includes the party's net incomes. No, you can't do that. Attaching the guidelines is not enough. You actually have to make findings of the party's net income in the order or in the judgment. All right, that's it for this week. Hope you guys enjoyed it. See you next week.